కూర్చోండి.
సార్ లైవ్ స్టార్ట్. లైవ్ స్టార్టెడ్ సార్. సార్ గో అహెడ్. సార్ గో అహెడ్.
Good evening to all of you.
చెప్పండి నేను చెప్పండి.
The topic for today is the Transfer of Property Act 1882. It's a law relating to dealing with immovable properties and all types of transactions related to immovable properties. This particular act was passed in 1882 and it has not undergone any amendment except section 106. When I come to 106, I'll let you know what is the type of amendment that has been brought about. First and foremost in every act is the definitions part of it. Definitions play a very important part in every enactment, and the meaning of every word that is used in section 2 or section 3 of every act shows the definitions and the interpretation which is given to every word. First and foremost is how immobile property is defined. Immobile property is defined as a negative definition is given. Immobile property does not include standing timber, growing crops, and grass. I'll come to each one of them separately. Here, as far as standing timber is concerned, sometimes what happens is trees are grown for the purpose of being commercially exploited. It is grown for the simple purpose that it will be severed from the earth and then it will be used for a commercial purpose like making furniture and for making centering poles and so on and so forth. So, as far as standing timber is concerned, if it is grown for a commercial purpose and there is no element of permanency in that and it is not going to be permanently embedded to the earth, it is not immobile property. Second one is grass. Grass we mean by what is called the fodder that is used for grazing, for the grazing animals like sheep, buffaloes, cows, etc. etc. Here the grass is grown for a temporary purpose and the grass is agreed to be severed from the earth and used for a commercial purpose like fodder, etc. It loses the character of an immobile property. So immobile property means it does not include grass for the simple reason that grass is not allowed to remain always. So there is no element of permanency as far as grass is concerned. First one is the standing timber, grass, and also growing crops. I think some of you are in agricultural operations know that you cultivate rice, you cultivate paddy first, or paddy, sugarcane, so on and so forth. But please remember, once the crop is ready, the crop is severed from the earth, and then the grass which is there, grass also is removed, and new seeds are grown, a new crop comes up. So there is no element of permanency as far as grass is concerned. That is the reason growing crops are concerned. That is the reason it is not immobile property. So negative definition of immobile property is immobile property means does not include growing grass, crops, and standing timber. So that is the first definition which you have to bear it in mind. Here, when we had a lecture on Sale of Goods Act, we said that in a sale, property in goods pass on from the vendor to the vendee for a consideration called the price. It is called a sale as far as the Sale of Goods Act is concerned. Here, sale is defined as where there is a transfer of title or rights in respect of immobile property from a person called the seller to a person called the purchaser for a consideration called the price. It is called a sale. And the person who sells the property is called the vendor, and the person to whom the property is sold is called the vendee. And what is transferred in a transaction of sale is ownership. Ownership is transferred. In Sale of Goods Act, we use the word property in goods. But as far as property is concerned, we use the word ownership. That has to be borne in mind before you go further. Then the next definition which is given is actionable claims. What do you mean by actionable claims? For example, suppose you have got Suppose I borrow a sum of rupees 50,000 from you and I execute in a promissory note in your favor and are coupled with a receipt. That promissory note and receipt is called a claim, which gives rise to an action in a court of law, and that is what is called an actionable claim. But actionable claim does not include mortgage, because mortgage is where an interest is created in specific immovable property as a security for the payment of the loan, which is paid promise, part paid, or part promise. Actionable claims does not come within the definition. The mortgages does not come within the definition of actionable claims. Any negotiable instrument, be it a check, be it a bill of exchange, or be it a promissory note, based on which you can initiate legal action against the opposite side, is what is called an actionable claim. Then the next definition which is given is the notice and constructive notice. What do you exactly mean by notice? Notice means the facts which are directly brought to the knowledge of a person is what is called a notice. Facts which are directly brought to the notice of a person is called notice. Constructive notice means even though a person may not be personally aware of the facts and he does not have knowledge of the facts, but law presupposes knowledge of certain facts which are presumed under the law. The classic example of that is once, let us say, a document is compulsorily registrable under the provisions of the Registration Act, it is reduced to writing and registered, then registration of a document concerning immobile property is constructive notice, even though you may not be knowing the facts or you may not have knowledge of the facts. The law presupposes knowledge of the facts, and this is what is called constructive notice. Then the next definition that is given is mortgage. Please remember the word T is silent. We pronounce it as mortgage, not mortgage. Mortgage means in agency area, it is called Tanaka. And in our area, that is in Telangana area, we call it as Girvi, because here in Telangana, we are half Telugu and half Urdu. That's the reason why Urdu words often find its place in our day-to-day connotation. Here, mortgage means where an interest is created in specific, please remember, note the word specific, where an interest also you have to underline, interest in specific in respect of specific immobile property created by the mortgagor for securing a debt, that is interest in specific immobile property created by the mortgagor in favor of the mortgagee for securing a loan, paid, promised, part paid, or part promised. It is called a transaction of mortgage. And the person who offers the property as security is called the mortgagor. And the person to whom the property is offered as security is called the mortgagee. And the transaction covered by this is called mortgage. Can you tell me the corresponding transaction in the sale of goods? I mean, the contract, sir. We are there. We have got the law of pawn or law of pledge. I think, if I'm correct, it's some 174 to 178 of the Contracts Act, which says where movable property is offered as security for the due repayment of a loan, it is called a transaction of pawn or pledge. And the person offering the movable property as security is called the pledgor or is called the pawner, and the person to whom the property is offered as security is called the pawnee or is called the pledgee. And please remember, in the law of pledge, what is offered as security is movable property, not immobile property. But in mortgage, what is offered as security is interest is created in respect of specific immobile property by the mortgagor in favor of the mortgagee to secure a debt which is paid, promised, part paid, or part promised. I'll tell you why paid, part promised. I'll tell you the reason is when you approach a financial institution, let us say a bank, for loan facilities, for working capital, for bill discounting, or for hyper, so on and so forth, then with there what you do is you create a mortgage. Mortgage is only immovable property is offered as security for securing a loan. Why would you say part paid or part promised? Suppose you apply for a loan of, let us say, 1 crore. The bank does not receive that, release that 1 crore immediately. What they do is they release part by part, step by step. And here, initially, they release about 20 lakhs, let us say. Then 5 installments, they release the other other remaining amount, that is 80 lakhs in installments. And that is the reason when the documents are taken, documents are taken towards the primary security, they are taken at the initial stage itself, and the further documents are not taken. That is the reason why the bank takes 3 documents from you every quarter. That is called COB. COB means confirmation of balances. Then AOD. AOD means confirmation of balances and acknowledgement that the debtor is indebted to the bank. And then the last one is revival letter. That is to say that the loan has been taken. There is an admission of the liability saying that the loan has been taken. Primary documents are taken at the time of sanctioning of the loan, and the primary documents taken hold good even for future transactions, and it stands extended. So no further documentation is taken as far as revival letter is concerned. Please bear one thing in mind: a banker will not put the date with pen. He uses the rubber stamp while putting the date. Why? Because the rubber stamp can always be manipulated. Then, so why we say part paid or part promised? That means if it is released in stages, every stage when the loan is released, it doesn't mean that fresh documents have to be taken. It means that the original documents which have already been executed stands good for all practical purposes, and they stand good for all purposes. That's why do we say interest? Interest we say because it can be a possessory interest, it can be a titular interest, it can be an ownership interest, or it can be any interest whatsoever. So that is called a mortgage. The next term that is defined. I've almost, when I was dealing with pleadings, I dealt with every type of mortgage. But anyhow, when I come to that chapter of mortgages, right from section 58 to 104, I'll discuss it in detail. Then the next term that is defined under the interpretation clause is what is called hypothecation. Hypothecation. Hypothecation means where it is called loosely called pledge of immobile property. Pledge of immobile property is what is called hypothecation. Here, it's something like a hybrid. Suppose, for example, my friend Mr. Vallabh, who is also a brother advocate, wants to set up a press. What he does is he goes to the bank, asks for working capital arrangements, and also wants to purchase that printing machinery with a bank loan. Then what the banker does is, sir, please try to take the catalogs from different shops, and whichever is profitable, you kindly purchase that machinery. We are prepared to finance you as far as the machinery is concerned. Please remember, I think there cannot be any doubt, machinery is supposed to be a movable property, isn't it? But machinery is not going to be kept loose. It is going to be embedded to the earth with nuts and bolts, fastened with nuts and bolts. So once movable property acquires the characteristics of immobile property by being fixed to the earth, attached to the earth, fixed by fastened by nuts and bolts, it acquires the characteristics of immobile property. That's why hypothecation is defined as pledge of pledge of immobile property. So previously it remained in the character of a mobile property, but once it is fixed to the earth with nuts and bolts, fastened with nuts and bolts, it acquires the characteristics of immobile property. That's the reason hypothecation. Please remember, if you read the book, nowhere hypothecation is defined. Even if you want to go through the Oxford Dictionary or the legal dictionary, hypothecation is not defined. Hypothecation simply means and includes pledge of immobile property is what is called hypothecation. And that particular movable property, which is converted into an immobile property by fastening it to the ground, by attaching it to the ground, or getting it embedded to the ground, it acquires the characteristics of immobile property. But if you remove the nuts and bolts, it loses the character of immobile property. Why? Because it becomes a mobile property. That's why it's something like a hybrid between a mobile property and immobile property. That is the reason it is defined as pledge of immobile, pledge of mobile, pledge of. That's why hypothecation is defined as pledge of immobile property. Then the property that is offered as security through the transaction of hypothecation is called the hypotheca, and the person in whose favor the hypothecation is created is called the hypothecatee, and the person who creates the hypothecation is called the hypothecator, and the transaction is called a hypothecation. That is as far as things attached to the earth. Then when I come back to the definition of immobile property, why it does not include growing grass, growing crops, and grass standing timber? Please remember, as far as trees, timber trees are concerned, they are grown for a commercial purpose. They are fastened to the earth. They are attached to the earth. They are embedded to the earth. But it is not going to remain there permanently. It is going to be severed and then taken to the market and used for commercial exploitation. That is the reason it does not come within the definition of immobile property. Then why do you say grass, sir? Grass also does not come within the definition of immobile property for the simple reason, though it is embedded to the earth, though it is fixed to the earth, it is not going to remain permanently. It is going to be cut and it is going to be sold in the market. That is the reason it's not an immobile property. It is not an immobile property also for the simple reason, sir. Once you grow a crop in a particular in your land, once you harvest your crop, the grass which is there, the grass which is left out is not left on the ground. It is severed and then sold as fodder. That's the reason there is no element of permanency as far as grass is concerned. Then growing crops, when you grow crops, when you suppose you grow paddy, if you grow paddy, once the crop is cut, the harvesting is done. Please remember the grass is removed from the surface and new seeds are put and new crop comes up. So when there is no permanency attached, though it may be embedded to the earth, though it may be attached to the earth, it is not immobile property. It continues to be a mobile property. So, now we come to the definition of the word gift. I think in Telugu they call it as Danamu, and in Urdu they call it as Tofa. Of course, I don't want to use the other word Nazrana. Nazrana is something which is exchanged by the Nizam for the purpose of acquiring a lady. Well, I don't want to go into that. Here, Tofa is the correct word. Tofa is what you get free of cost. Gift has been transferred as where there's a transfer of immobile property from one person called the donor to a person called the donee gratuitously without any consideration out of natural love and affection. It is called a gift. Please remember here you don't have the word giftor and giftee. The word that is used is donor and donee, and the transaction is called a donatio or it is called a gift. Then what are the elements of gifts? One is there must be transfer of immobile property from one person called the donor to a person called the donee. Second one is since in the Contracts Act, every contract has to be supported by consideration. A contract without consideration is a nullity and a nudum pactum, and it is not enforceable. That is the reason the word that is used is gratuitously out of natural love and affection which the donor has for the donee. And please remember, like a contract, there must be an offer of gift and there must be acceptance. And as far as a gift is concerned, it is a bilateral document. Both the donor and the donee has to sign. A donor signs it in token of having offered the property as a gift, and the donee signs in token of having accepted the gift in toto. That is why in the Contracts Act, the first maxim is an acceptance is to an offer what a lighted match is to a train of gunpowder. Please remember, suppose a tree of gunpowder is found, and so long as it is not ignited or you don't set fire to it, it remains gunpowder. But once you light the match, there's a big explosion, and not a single particle of the gunpowder can be retrieved. That is the reason, that is the effect of acceptance. So, the essentials of a gift is there must be immobile property. And there must be two persons competent to transfer, of course, offer of gift and acceptance by gift. An offer made and accepted in toto by the donee completes the gift, and it is normally signed by both the donor and the donee. Here, one thing you must remember is whatever is gifted should be within the disposing capacity of the donor. In Telugu there is a saying, "Attosamu alludu danam chesinattu," లేకపోతే in Urdu they say, that is "Lala ke dukan mein nana ki fatiha." That means when it does not belong to you, you are very, very philanthropic. You cannot find a generous person like you. But the question is, besides the question is, you are not the owner of that. It is some other's property you try to sell. That's why when we come to 37, 38, 39 of the TP Act, they have got a maxim called nemo dat quod non habet. No man can pass a better title than what he himself has. Then, as far as here, I have to make a distinction, sir. As far as Muslims are concerned, no documentation is necessary. Only thing is oral gift can be made. That is what is called hiba nama. Hiba can be made, but there are. Please remember, we people forget. We read in between the lines. But if it's going to be a Muslim gift, there must be an offer of gift and there must be acceptance of gift. But one important thing, as far as a Muslim gift is concerned, there must be delivery of possession. Possession has to be given. Without possession, there cannot be a Muslim gift. So, as far as a Muslim gift is concerned, it can be done orally. But one thing is this: what most of the Muslims do is they reduce it in the terms, reduce it in the form of a memorandum, saying that the gift has already taken place, and the concern, that is, please remember, possession means actual possession, physical possession, symbolic possession, or constructive possession. Here, why I'm using the word constructive possession is, suppose a Muslim, the donor, has got tenants in respect of the property. Then what the donor does is, once he says he has gifted the property orally, either to his wife or to his son or to his daughter, whomsoever it may be, he goes and informs the tenants, look, I am not the owner anymore. My son is the owner of this property. I've orally gifted the property to him. I am attorning him. That is, in Urdu, they call it as taslim karna. Taslim karna bole to, that the question is, you go and introduce your donee to the tenant and say, in future, you don't pay rents to me, pay rents to my son. I've gifted my property to this person. So, as far as Muslims are concerned, oral gift is permissible. Please remember, Muslim is an exception in this country for everything. You don't have a uniform civil law, you don't have anything for them. But still, as far as this is a Sharia, they say oral gift can be done, but accompanied by possession. Unless it is accompanied by possession, actually it may be physical possession, it may be symbolic possession, it may be what is called vacant possession. It can also be constructive possession by attorning the tenant. Attornment in Urdu, they call it as taslim karna. That is, you take your son to whom you have gifted the property, or take your wife to the tenant and say or you give it in writing saying that I gifted my property to my wife, so and so, Mrs. So and so, Abida cartoon or whatever cartoon it may be. The question is, the gift has to be informed to the tenant. So taslim, that is, if you attorn the tenants to your doni, it is sufficient. But please remember, in Muslims, possession is absolutely necessary. Without delivery of possession, there cannot be a Muslim gift. That is, usually it is called the hiba nama or hiba transaction. But sometimes we develop some affection to certain outsiders. In Parsis, there is a custom normally that no Parsi gets married till he attains the age of 50 years or 60 years. Then the servant maid of the house is almost his mistress. She looks after all his physical and other comforts. Then, out of natural love and affection for the servant maid, he gives the property. Then, please remember, in that case, there is a distinction made as far as stamp duty is concerned. Among blood relations, the stamp duty which is leviable is 1% to 3%. But as far as an outsider is concerned, it is 5% stamp duty that has to be paid. But please remember, all these transactions after are subject to the provisions of the Registration Act, more particularly Section 17 of the Registration Act, which is every transaction relating to immobile property has to be in writing and has to be duly registered. And all transactions relating to immobile property or leases which reserves an annual rent has to be in writing and has to be duly registered. And to be more precise, it is Section 17(1)(b) of the Registration Act as amended and effective from 1/7/2001. So I think in the earlier classes, some students asked me, sir, we can take the lease for 11 months. We need not get it registered. Please remember, even if the lease is for 1 month, the statute is very, very clear to say that it has to be in writing and the proper stamp duty has to be paid and it has to be duly registered. So please remember that's why in Telugu they say, Devudu varamichina pujari addu vachadata. That means even the God is willing to give you a gift, the government comes in and say, where am I? First recognize me, then the God. That is how, and please remember the government now, especially the present government here in Telangana, is start of finances. They want to tap finances at every stage possible. So please remember, you as an advocate cannot say, sir, I'm ignorant of this provision 17(1)(b). Please go through 17(1)(b). If you have not gone through till now, at least now read 17(1)(b) and say every transaction which creates a right, eliminates a right, and also it creates new rights in respect of the property has to be in a properly stamped paper, and it has to be properly registered. Then the question arises, sir. I'm sorry, sir. Mostly the companies who are assisted by able company secretaries are not advising the companies also properly. Nowadays, you have got a hybrid document which has come into existence, which is not found in the law of conveyancing, called the MOU, or what is called the Memorandum of Understanding. Memorandum of Understanding is both of us sit across and then talk to each other, and he exchanges his thoughts and I exchange my thoughts, and we put it in writing. That they call it as MOU. That is, it is called tete-a-tete talks, face-to-face talks. Or the question is, all these talks they reduce. Please remember, this has been borrowed from America. Nothing is found in India. MOU has also come from foreign countries. But please remember, under 17(1)(b) also, and MOU also has to be registered. MOU also has to have proper stamp paper. Then coming to another hybrid document called Development Agreement come General Power of Attorney. Development Agreement come General Power of Attorney. Suppose you have got an old house. Let us say one builder wants to develop your property into a residential complex or into a commercial complex. First and foremost is he has to be given the powers. Powers in the sense he has to meet the government officials. He has to liaise on your behalf. He has to apply for a permit. He has to apply for clearances. He has to look for prospective purchasers. He has to enter into agreements for and on behalf of the owner, and then and the entire finance is spent by him. But please remember, he has got a right of sharing in the constructed area. That is the reason, sir. Now most of the old buildings have been reduced, have been converted into commercial buildings or residential buildings, and there is an understanding that the builder will get 60% and the owner will get 40%. And the development agreement itself, they say, suppose it is going to be a 5-story building. Let us just assume 20 flats are coming, and ground floor, it is not residential flats, but it is only purely commercial. And please remember, the builder will be more interested in the commercial rather than the residential one. Why? Because commercial fetches you that pagadi or goodwill which you get. And that goodwill, you can spend whatever money you have spent for financing the project, you get that money. And then the owner is given 40%. 40% doesn't mean that you get it in one floor. In one floor, you get one flat, another floor, you get one flat, another floor, you get one flat, another floor, you get one flat. So reduce it in the form of a development agreement, how it has to be developed. And then a Mukhtar Nama, or what is called a power of attorney, also is coupled along with that. That is, there they say that the power of attorney has got the right of liaising or contacting the necessary authorities based on the power that is given to him by the owners. And this is called Mukhtar Nama, or it is called the power of attorney. There, please remember, now under 71(b), even a development agreement come general power of attorney has to be compulsorily registered with proper stamp paper. Then I also like to invite you to this, because we are dealing with the interpretation clause only. There is one case of 2004 or 2005 Supreme Court, popularly called the Suraj Lamb's case versus the Delhi Development Authority. In that particular case, a suit for specific performance was filed to enforce an agreement which was in the form of an AGPA, or what is called agreement come general power of agreement of sale come general power of attorney. There the learned judges, I think it was the judgment of Justice Ravindran of the Supreme Court, who said if it is in the form of an AGPA, the people are entering into AGPA for the simple reason to avoid stamp duty. So the question is, even an AGPA, the entire consideration has to be paid, the entire stamp duty has to be paid, and there must be a recital that the complete sale consideration is received and the entire stamp duty is paid, then only you can enforce that agreement. But as far as sale deed is concerned, it's a formality. After 6 months, also you can get the sale deed executed. But at the time of sale deed, no stamp duty is collected from you, no registration fees is collected from you, because everything is like nowadays we have prepaid what is called cell phones and postpaid cell phones. Prepaid means you pay it earlier itself, but for that period you can use it. Postpaid is every month you pay the bill. Here it's not so. Suraj Lam's case, they said the entire stamp duty has to be paid and the entire registration has to be paid. Then alone the AGP is enforceable and you can get a degree for specific performance. Why I'm trying to tell you this is I got into trouble, practical problem with the court at Siddipet. I think that was the district judge, 6th additional district judge, Siddipet. I think now she is the principal district judge of Karimnagar. I don't want to give her name also. Here, what happened was my colleague was involved in this problem. And the judge was harping, there is a Suraj Lam's case. Suraj Lam's case says AGPA is not enforceable. So how can you ask for specific performance? That was a legal query that was put by the judge. I simply answered her by saying, sir, you are citing Suraj Lam's case in every case. Please remember, Suraj Lam's case can be distinguished in this way that as far as my suit document is concerned, AGPA is concerned, the entire consideration is paid. There is an admission and acknowledgement of the payment of the sale consideration, and also it has been registered. So Suraj Lam's case does not apply as far as my case is concerned. On that point, I succeeded in that case. So when a case law is cited and the judge is adamant, because judge knows only few case laws, sir, they try to throw a rabbit on us by saying, Suraj Lam's case, your specific performance suit is not made. Don't get despair. You see whether the entire stamp duty has been paid, the entire registration fees has been paid, the entire consideration has been paid. The Suraj Lam's case does not apply as far as your case is concerned. Your interpretation has to be proper. Why I'm trying to tell you all these things is these are all the practical anecdotes which arise in our day-to-day practice. Then, next one, here we go to section 5. How transfer of what is the scope of Transfer of Property Act? The question often arises. There's a question which is asked mostly in the law examinations as well as in the competitive examination also. Is the Transfer of Property Act an exhaustive provision of law? Does it cover every transfer of immobile property? In this regard, sir, I would like to differ by saying Transfer of Property Act is not an exhaustive provision of law. Why? Because it covers only specific items like sale, gift, mortgages, lease, and exchange, and actionable claim perhaps. But there are certain transactions which are not covered by the Transfer of Property Act. For example, you take the case of a will. Take a case of a will. Will is supposed to be a testamentary transfer. It does not operate immediately during the lifetime of an individual. It operates after the demise of an individual, and that's the reason it does not come within the Transfer of Property Act. Then you take the case of a partition. As far as partition is concerned, earlier it was a composite property where there are joint rights in the property, something like an ice cream loaf. When in marriages, normally nowadays it's a fashion, as a dessert, they serve ice cream. And when it comes in the form of a loaf, you don't consume that loaf immediately. What you do is you make it into small pieces, small slices, and the slices are served on you, which you take and eat. So here, as far as partition is concerned, there is a joint status among the family members, and they are joint. The property is joint. But by partition, what they do is the very property which is available, it is divided into fragments, divided into pieces, allotted to each and every party. And this is not covered by the Transfer of Property Act. So every type of transfer of immobile property does not come within the definition of the word transfer of property. Then you take the case of a release or you take the case of a relinquishment. As far as the release is concerned, or relinquishment is concerned, suppose let us say, of course, you don't have Hindu joint families now, except in Vaishyas, perhaps that HUF is still continuing. But there, what they do is, for example, take case of family settlement. Before we go to that, take the case of a family settlement. The family members sit, the karta of the family sits along with the sons and daughters and his wife, and then distributes each property, each bit to his sons and his daughters or to his wife. Here also there is a settlement of property. That's why we call it a family settlement. Family settlement does not come within the definition of transfer of property. But there, please remember, దేవుడు వరం ఇచ్చిన పూజారి అడ్డు వచ్చాడంట. Even a family settlement, as per the present law, requires registration. Then in Vaishyas and Kammas, there is a custom called Pasupu Kunkuma. As far as, because I still remember when I was the standing counsel for banks, these family settlements used to, Pasupu Kunkuma documents used to come. And the question that arises is whether it requires a stamping, whether it requires registration. The earlier view taken was that as far as a document which is executed, giving a share to a female, a daughter of the family towards a marriage settlement does not come within the definition of transfer of property. It did not require registration. But the government came later and say even if it's given to us 3 it has also to be reduced to writing and it has to be registered. It does not come within the definition, of course, transfer of property act. Then you take the case of a release deed or a relinquishment deed. The question is, what do you mean by release? Release means where, let us say, there are 4 sons. And let us say each son is entitled for 25%, 25%, 25%, 25% share. Then one of the sons does not want that 25%. What he does is he releases his rights in respect of the property, his share that has been allotted to him, and releases it in favor of his elder brother or younger brother. That is, he says, from now onwards, I will not be the owner. My share also will go to my brother, younger brother or elder brother. That is what is called, already the property is there, but it has been divided to fragments by way of allotment of different shares. But one of the sharer wants to release his rights in respect of that property in favor of his other brother. Previously, what we used to do, I still remember when I started practice, we used to draft it on a 30 rupee stamp paper and get it registered. But later on, the government woke up and said, even a release deed is supposed to be a conveyance. So you have to stamp it as a conveyance and then pay the stamp duty and also get it registered. Then relinquishment deed. What do you mean by please remember, release and relinquishment means 2 different things. Relinquishment means, suppose the property is in the name of husband and wife. Of course, you don't have Sati Savitris and Sakubais now. The question is, suppose, let us say, 50% belongs to the wife and 50% belongs to the husband. Then what the wife says is, my dear husband, you have looked after me very well. You have given me all the comforts. You have attended to my medical and physical needs. And we have also got children. They are happily settled. In consideration of that, though the property is purchased by us jointly, I am relinquishing my 50% of my share in the property in favor of you, Mr. Husband. Then she gives up her share and then gives it to the husband. So the husband, who was the owner of only 50%, becomes the owner of 100% by virtue of this relinquishment. This relinquishment or release deed does not come within the definition of the Transfer of Property Act. Is it not a myth? Do you say that the Transfer of Property Act is an exhaustive provision of law? No, it does not deal with any transfer, all types of transfers that you visualize. That is the reason the first question which is answered in the affirmative is the Transfer of Property Act is not an exhaustive provision of law. It does not deal with all types of transfers. Then we go to Section 5. Section 5 says how transfers of immovable property is effected. First and foremost condition is transfer of immovable property can be made only inter vivos. Inter vivos means transfer can be made only between 2 living persons. You cannot make a transfer in favor of a ghost. You cannot make a transfer in favor of a person who is not existing on the date of transfer. You cannot make a transfer in favor of a dead person who is no more available. So the transferor should be alive and the transferee also should be alive. Then only the TP Act applies. So first and foremost rule, as far as Section 5 is concerned, transfer of property can be made only between living persons, or what is called in the legal language transfer inter vivos. It rules out a person who is a transferor who is not living on the date of transfer, or the transferee who is not living on the date of transfer. In this regard, I'll just give you a brief resume as to how this happens. There are some communities like what is called Vaishya community and Kamma community. Whenever a uh, child arrives in the family or is about to arrive in the family, or in legal language is avant same, even avant en space ventre ventre sa space sa space mare mare. That is a child which is in the womb of the mother is called avant same. This is a Latin word that means a child which is avant same. As for the provisions of the Bharatiya Sakshya Adhyan, there they say the period of gestation for a woman or undergoing the pregnancy or the gestation period is 270 days to 280 days. 270 days in the case of a male and 280 days in the case of a female. So, mostly this prosperous communities, I'm not talking about middle class and lower middle class, they eagerly await the arrival of a child. Why? Because the child, not that these people are going to be attracted toward the child. No, the child is going to arrive on the scene to relieve the parents of their tax liability. So what they try to do is the mother is pregnant, mother is undergoing the period of gestation, and in anticipation of the child being delivered, or let us say the mother, no doubt, there is a suspected pregnancy, the fetus has not grown, the child has not come into the womb also, in expectation of the child coming into existence, a property is transferred in favor of the child which is not born at all, or which is not in the mother is not in the process of conception. Then in that case, the Transfer of Property Act says that cannot be made. But there is an exception. Please remember, and that's why it said legal profession is such a profession. A lawyer excels more in the exception rather than the rule. There they say a transfer cannot be made directly in favor of an unborn person. A transfer cannot be made in favor of an unborn person who is not even in existence on the date of transfer, or who is not even avant sa-mère, that is in the womb of the mother, and the mother is not undergoing the period of gestation or pregnancy, as you may call it. Then in that case, the question is a transfer cannot be made directly in favor of that unborn child. But if a transfer is to be effective, no doubt you can make a transfer. First, you must transfer the property in favor of a person who is living on the date of transfer. And as soon as the child comes into existence, the child gets an absolute interest. Is it not a misnomer, sir? The question is, you create as many. The question is, you cannot say as many children she has, the properties will go. No. But that child which is going to arrive, first you must make a transfer in favor of a living person. And the living person, as soon as the child comes into existence, that unborn child comes into existence, that child gets a vested interest in respect of the property, though the enjoyment of the property's transfer is postponed till the attainment of majority. That is section 10 to section 13 of the Transfer of Property. When I come to it, I'll deal with it in detail. Because this was, by the way, I was discussing when I'm discussing the definitions part of it. Then, sir, when we discuss gifts, there you got a doctrine called onerous gifts. Onerous gifts means gifts burdened with obligations, gifts burdened with liabilities. Suppose the father has mortgaged his property to a bank. He wants to give that property to his son. But in the gift deed itself, he says, "My dear son, I have got these debts. You have to clear the debts on my behalf, and whatever you clear, the property is yours. Here, the donee is put to election whether to take the property with the liabilities or without the liabilities. Please remember, once you want to have the cake and eat, you cannot have the cake and eat it too. Once it's burdened with obligations, once it is burdened with onerous responsibilities, you must discharge those burdens first before you get the property. That is called onerous gifts. Then another definition which is also given is donatio mortis causa, DONATIO space, mortis, MORTIS space, causa, CAUSA, donatio mortis causa. That is a gift made in anticipation of death. Please remember, when a person is in the deathbed, he becomes very, very charitable. What he does is, please remember, this can take place only regarding movable property, not regarding immobile property. Here, a person expects his death at any moment. Then he calls his daughters and daughters-in-law also. Then what he does is, he has got a big Parker pen, old, very old Parker pen, or he has got a Scotch whiskey, which is about 100 years old. He says, he calls his son and says, I've got a very good, I've got about 10 bottles of Scotch whiskey. I'm gifting it to you. Please take it. And in my remembrance. But please remember, this gift which is made by mere delivery of possession only regarding movable property is effective. But sometimes it so happens, the person who is in the deathbed has not gifted even a pin during his lifetime, but the son gets a heart attack and he dies before the father. Then what would happen to the gift? Gift fails. Why? Because the transferee also should be alive to take the gift. So if the transferee is not alive, the gift will not work. Then universal, there's one more gift which is defined in the Transferor Property Act called universal donee. Universal donee means a person to whom the entire property, including movable and immovable property, is gifted, except an insignificant portion which is kept apart for the maintenance of the donor. Such a donee is called a universal donee. These are all the various definitions that you can find in the earlier sections. Then we go to the most important section called section 6. What are the properties that cannot be transferred? What are the properties that cannot be transferred? First, A6A says, a chance of a spes successionist cannot be transferred. Means a chance of an heir apparent to succeed to the property cannot be transferred so long as the transferor is alive. This happens in all the big financial families where the son says, any moment my father may kick his bucket. He asks Nade, Anta Manade Anko. So the question is, he enters into an agreement with Mr. Valla Venkateswara, saying that I'm transferring this property. Please remember whether this person transferor has got a right. He has only got a chance of succeeding to the property. That is what is called spes successionist. He may succeed, he may not succeed also. The old man, knowing the designs of his beneficiary, what he does is he writes it in favor of the Ramakrishna mission or gives it to the TTD, that is Tirumala Tirupati Devasthan. The question is, the person who takes such a property from a person who has only got a chance to succeed cannot be transferred till the old man dies. Then second one is right of re-entry, which is available only to the lessor, cannot be transferred to any third person. What do you mean by right of re-entry, sir? Suppose, let us say, the tenant or the lessee commits a default. Just 1 minute. इधर एक दुकान खुला है. So first, can I carry on? Yeah. First one is 6A. Chance of an heir apparent to succeed to the property, which is called spes successionist, cannot be transferred. That means A mere chance of a successor who is to get the property after the demise of his father or any other person cannot be transferred so long as the person is alive. That person means the transferor is alive, or the person from whom he has to get the property is alive. A chance of a swift succession is cannot be transferred. Second one is a right of re-entry in case of violation of the terms of the lease cannot be transferred. What do you mean by right of re-entry? Suppose, let us say, I am the landlord and you are my tenant. Suppose I say you commit a default in payment of rent, or you are liable to vacate on some ground under the TP Act or whichever ground it may be. Then I cannot say, new entity, you take possession of the property. I get that's a third person. I say, you go and take possession of the property. I will remain the landlord. That cannot be done. I should ask for possession by myself, and the right of re-entry is available only to the landlord and only to the lessor and not to any third person. That is the second one. The third one is the easement can that is a mere right of re-entry for business. Then third is easement cannot be transferred apart from the without the dominant heritage. In the law of easements, there are two types of heritages which are provided. One is called the dominant heritage, and another is called the servient heritage. What do you mean by dominant heritage? Dominant heritage is the title or rights, proprietary rights, all rights in respect to the property are transferred by the transferor to the transferee. That is called the dominant heritage. Then what do you mean by servient heritage? Servient heritage is the easementary rights which you acquire by long possession for 20 years, let us say, right of light, air, sanitation, ventilation, ingress, egress, and the right to use a particular one for reaching your field, or right to use irrigation water, right to worship at a particular place. All these rights which you acquired in respect of your neighbor's property is what is called servient heritage, or what is called easementary right. Then in that case, these easementary rights cannot, the servient heritage cannot be transferred without the dominant heritage. So if that person to whom you are going to transfer, you should transfer both. You cannot have the dominant heritage with you and only the easementary rights you cannot transfer to a third person. That is prohibited as far as section 6 is concerned. Then the fourth one which is prohibited is an interest in property restricted to the enjoyment of the owner personally cannot be transferred by him. What do you mean by that, sir? That is, it says that an interest in property restricted its enjoyment. For example, you go to the railway platforms, or you go to what is called, you are working in a public sector undertaking, or you are working with the central government or the central state government. Then let us say some of the employees are entitled for rented free leased accommodation, or the quarters which are built by them, it is given to you because you are in service. This you cannot transfer it to some other person because this interest, or let us say judges' quarters, the quarters which are allotted to judges in consideration of the services rendered cannot be transferred to a third person. That interest is only for you, not for anyone else. So section 6 clause 4 says an interest created for the purpose of personal enjoyment of a person cannot be transferred. Then next one is a mere right to sue cannot be transferred. A mere right to sue cannot be transferred. Suppose, let us say, a libel or a slander takes place, or what are called commonly called as the defamation takes place. As far as I am concerned, I am the person defamed. I am the person who has become a victim of defamation. I am the person who has become a victim of what is called libel in a printed matter, or slander by words of mouth or by conduct. Then in that particular case, I alone can file a suit. I cannot delegate these rights, transfer these rights to a third person. I think we'll stop with this and go in detail each section by section. Please remember, people who are practicing on the civil side, people who are coming across the Transfer of Property Act in our day-to-day practice, you must have a thorough knowledge of the Transfer of Property Act. At this stage itself, I want to make it clear to you, sir. I've received some adverse remarks from some of the channels. What they are saying is that this is meant for public publicity. Please remember, I have got about 52 years of standing. I have put in enough experience. And please remember, at the instance of my colleagues and also instance of some of the well-meaning advocates, I am doing this as an honorary job. I am not paid anything for it and not for commercial interest. If anyone is aggrieved, anyone is peeved, let them do what they want. I am not concerned with that. If you want me to stop at this, I will stop. If you don't want me to stop, I'll go ahead with my lectures. Please remember, such type of adverse remarks by people is not welcome. Please try to avoid such adverse propaganda or publicity. Please remember, I don't get a pie from these lectures. It is only out of experience and only out of I want to expose you people also to legal knowledge. Please bear one thing in mind. I have no financial interest in this. God has given me sufficiently. I need not depend on this. Please try to avoid such comments in future. Thank you. Now the interaction period.
One interaction. Good evening, everyone. Any objections in continuing the classes? Please go ahead. If you have any objections to continue with the classes online, because we have received such a kind of adverse comments on us, we are not here to do that. It's not a commercial activity what we are trying to do. Please understand that. If you have an objection, or please put your comments on your chat box. Everyone, I request everyone to put your chat, any objections you have in chat box. Raise your objections. Because we are feeling very awkward in certain kind of comments which are passed against to sir as well as us. We are not here to hear that voice. This is an honorable job, what we are trying to do. Please try to understand. If anybody have any objections, please go ahead. We will stop it right away. You can raise your voice. If you want to speak, you can unmute your mic. Go ahead with speaking. Ma'am, unmute everyone. You are unmuted. You are free to talk. One by one, you can unmute your mic and you can free to talk.
Sir, వినపడుతుందా సార్? Sir, we are feeling honored, sir. Having a conversation direct. We got to listen to you like this. It is a great platform for us, all of us. We don't have any objection.
Mrs. Lavanya, to be frank, I have got a good practice. To be frank, I want to help you also, the fraternity. I am not paid a pie. It is purely
very rarely we get a chance to have a conversation.
I'm not bothered by such comments being made. I'm ignoring those comments. Please give your opinion.
We are not bothered about the comments, but the only thing is it is very bad to see that kind of comments.
And we don't make comments about other.
What is happening is, Aynana Topa ila maatladunnarandi. These are the comments from our own fraternity.
Kindly ignore, sir. Ignore and move on, sir. You might have seen, many like this.
Thank you very much. My father used to say the very thing that the people are talking against you. Itself means. Yevandi? Please. Thank you, Lavanya.
Thank you, Lavanya. Anybody has any objection?
Hello, sir. This is Uday.
Yes, sir.
Uday.
Sir, really.
One by one.
సార్ అది వినడానికి కొంచెం చాలా బాధాకరంగా ఉంది సార్. నేను ఇలాంటి ట్రైనింగ్ కోసం ఆల్మోస్ట్ 2 years నుంచి చూస్తున్నాను సార్. From 2 years I am waited.
Yes, sir.
I'm literally feeling so happy from the last 1 month by listening your words. But sir, మీ ఎక్స్పీరియన్స్ లేదు, నా వయసు. Sir, please don't consider this words, sir. So
thank you.
People are
some of the bar associations are deleting our own my own comments and they are not answering us. మేము క్వశ్చన్స్ అడుగుతున్నాం, డైరెక్ట్ గా క్వశ్చన్ ఏంటి మీ అబ్జెక్షన్స్ అని అడుగుతున్నాం. They are not even answered to bother of the questions also. They are doing this kind of activities in their groups. It has become a big mess in the groups, in the WhatsApp groups.
Anyway,
how many questions will answer it?
Anyway, ignoring it, sir.
Please
but
ignore them, sir.
your goodwill is always there with us. We'll continue.
100 between the Samitundi, like the one the apples machine of apple and so on, it will affect for all.
Sir,
So
Uday garu, నేను కానీ మా admins కానీ ఏ ఛానల్ మీద మేము కమెంట్ చేయలేదు. We don't give such nasty remarks also, sir. We are not bothered
Sir,
about.
everywhere one person will be there to spoil the atmosphere.
You're right. You're right.
So there is no necessity to consider that, sir.
Yeah, thank you.
We are really feeling very good for listening this type of classes, sir.
Thank you, sir.
So
Thank
there
you.
is no need to bother about
Look at
that
this,
type
madam.
of
Look
fellows.
at
Why?
this,
Because
madam.
everybody there to spoil the good
Madam, I am
atmosphere,
showing the
sir.
WhatsApp conversation. What I put here. Look at this, madam.
Sir,
Direct.
actually, it is not clear to me, sir.
I am
Thank you.
showing it to everyone.
Thank you, ma'am.
I am from BBA, sir.
Yeah.
Really, it's a wonderful class, sir.
Thank you, ma'am.
And I have some doubts also. I wanted to be clear that too.
You can.
Okay.
You can.
Sir, good evening.
Sure,
Good
sir.
evening, sir.
Good evening,
This
sir.
is Ramakrishna, Hyderabad, sir.
Yes, sir.
Sir, this is Ramakrishna from Hyderabad, sir.
Sir,
సార్ మీలాంటి వాళ్ళు కావాలి సార్ సమాజంలో మాలాంటి కొత్తగా నేర్చుకునే వాళ్ళకి యు ఆర్ ఏ మూవింగ్ ఐ ఎన్సైక్లోపీడియా సార్.
thank you very much, sir, for your.
చదువుతుంటే కూడా కొన్ని అర్థం కాని విషయాలు మీరు ఇంత క్లియర్ గా చెప్తున్నారంటే అటువంటి తొక్క తీసి నోట్లో పెట్టి ఇలా నమ్మలాలని చెప్తున్నారు సార్.
Thank you, sir.
లిటరలీ
Thank you,
కొన్ని
sir.
లీగల్ లాంగ్వేజ్ లు డిక్షనరీ చూసినా గూగుల్లో చూసినా దాని మీనింగ్ ఉంటుంది కానీ అది అనలైజ్ చేయలేకపోతాం.
Sir,
అలాంటిది కూడా మీరు క్లియర్ గా ఎక్స్ప్లెయిన్ చేస్తుంది సార్.
Thank
వి
you.
నీడ్ పీపుల్ లైక్ యూ.
sir.
మీ లెగసీ అలాగే కంటిన్యూ కావాలి సార్.
Thank you, sir. Thank you, sir. Thank you.
Thank you.
one thing to add, Ramakrishna garu sir. యాక్చువల్గా మీరు ఫస్ట్ క్లాస్ చూసి మీరు బుక్ అది చూస్తూ చెప్తున్నారేమో అనుకున్నాను. తర్వాత చూస్తుంటే అసలు బుక్ తో కూడా ఎక్కడ గ్యాప్
లేదు సార్.
నేను 28 years యూనివర్సిటీ చేశాను సార్. I taught about 16 subjects. I never used a book in any of my classes.
దట్ ఇస్ వాట్ సార్. నేను ఆ తర్వాత చూసిన తర్వాత
I don't give credit to me, sir. I give credit to my genes. My father was my senior, or my mentor rather.
సార్ చెప్తుంటే సార్ ఫేస్ ని ఆ కళ్ళని చూసి చెప్పచ్చు. బుక్ చూసి చెప్తున్నారా ఆయన బ్రెయిన్ లోంచి హార్ట్ లోంచి క్లియర్.
That is what
అంటే
I am
సారు
telling. I am accepting it.
కొంతమందికి ఆ బుర్రలో అదేంటారు సిపిసి బుక్ నా లోపల ఇస్త్రీ చేసి పెట్టుకున్నాడు.
ఇట్స్ గాడ్ గిఫ్ట్ సార్. ఇట్స్ గాడ్ గిఫ్ట్.
మీకు యాడ్ అంటు ద కామెంట్ అదేమంటారు సిపిసి బుక్ ని బాగా మడతేసి ఇస్త్రీ చేసి పెట్టుకున్నాడు లోపల.
Thank you very much.
జోక్స్ పాట.
Thank you very much.
మీరు చెప్పిన క్లాసెస్ ఫర్దర్ చాలా ఉపయోగపడతాయి సార్ అందరికి.
Thank you.
Thank you very much for the
It
entire
really
course.
shows that people are much jealous on you, sir.
Exactly,
Yeah,
sir.
they are coming
I
from
feel
jealous.
proud about it. Someone to recognize my ability.
Yes.
అంటే దేవుడిని దినాన్ని తిట్టేవాడంటే హిరణ్యాక్షుడు, అలాగని హిరణ్యాక్షుడు లేకపోతే తాటకి లాగా తీసుకుంటాను అంతే.
మీ ఎబిలిటీ మూలంగా వాళ్ళ బిజినెస్ దెబ్బతింటుందని బాధపడుతున్నారు.
సార్ బిజినెస్ కాదు సార్ ఇది. ఒకటే మాట చెప్పారు ఆయన. నాతో చెప్పిన మాట ఏంటంటే ఈ ప్లాన్ వాట్ ఎవర్ దిస్ ఇంటరాక్షన్ ఇస్ లాస్ట్ 2 years. దిస్ ప్లాన్ ఇస్ లాస్ట్ 2 years. 2 ఏళ్ల తర్వాత ఈ పోర్ట్ తీసుకురాని 2 years పట్టింది మాకు.
సార్ తులసి వనంలో గంజాయి మొక్కలు అక్కడక్కడ ఉంటాయి సార్, అవి పట్టించుకోవద్దు సార్ ప్లీజ్.
నేను గంజాయిత కానండి.
సమాజం
నేను గంజాయిత కాను.
లేదు సార్, కమెంట్ చేసే వాళ్ళు అంటున్నారు. కమెంట్ చేసే వాళ్ళు గంజాయి మొక్కలు లాంటి వాళ్ళు, వాళ్ళు ఎప్పుడు అలాగే ఉంటారు, వాళ్ళు మారరు, చెట్టు మారదు.
థ్యాంక్ యూ వెరీ మచ్.
వాళ్ళని కేర్ చేయకూడదు.
థ్యాంక్ యూ వెరీ మచ్.
మీరు చెప్పాలి సార్, మీరు చెప్పేది చాలా ఉపయోగపడుతుంది సమాజానికి, ఫ్యూచర్ లో ఫ్యూచర్ జనరేషన్స్ కి. ఇలాగ చెప్పే వాళ్ళు నేనైతే ఇంతవరకు చూడలేదు సార్.
థ్యాంక్ యూ సార్.
అండ్ ఇట్స్ గాడ్స్ బ్లెస్సింగ్ ఫర్ యూ. ఐ విష్ లాంగ్ లీవ్ సార్. మీరు చాలా
సార్ ఎనీ క్వశ్చన్స్?
ఉదయ్
సార్ మీరు చెప్పండి సార్, క్లాస్ కంటిన్యూ చేయండి. వేరే వాళ్ళు ఎవరేమన్నా కూడా అవసరం లేదు సార్.
థ్యాంక్ యూ సార్. థ్యాంక్ యూ సార్.
పట్టించుకుంటున్నారు
సార్. నౌ ద క్వశ్చన్ హియర్ ప్లీజ్. వసంత్ గారు చెప్పండి.
సార్ ఏ సీనియర్ దగ్గర 10 సంవత్సరాలు వర్క్ చేసినా కూడా ఇట్లా నాలెడ్జ్ షేర్ చేయండి సార్. ఆల్వేస్ కీప్ ది జూనియర్ ఇన్ ద డార్క్ సార్. వీళ్ళంటి వాళ్ళు చూసి ఈ రోజు నాకు స్టాండింగ్ స్టాండింగ్ ఉన్నా కూడా రెగ్యులర్లీ అటెండింగ్ యువర్ క్లాస్.
థ్యాంక్ యూ సార్.
అండ్ ఎవ్రీ క్లాస్.
థ్యాంక్ యూ సార్.
నాకు తెలుసు. స్టిల్ ఐ am considered myself as an innocent person sir in the law.
థ్యాంక్ యూ.
Always I am considered to be a student. ఎక్కడ చిన్న క్లాస్ ఉన్నా కూడా ఎంత వర్క్ ఉన్నా కూడా నేను అటెండ్ అవుతుంటా
థ్యాంక్ యూ.
క్లాస్ అయినంత.
I know Vasant garu, you are a regular interaction person. You even give some kind of మీ దగ్గర ఉన్న కేసులో డిస్కషన్ అవుతున్నది. I know that, sir.
If an occasion comes, I will come Hyderabad and I will personally meet you.
Thank you,
Really,
sir.
I am
Thank you.
very much
Thank you, sir.
Thank you.
పర్సనల్ మీటింగ్ పెడతామన్నారు సార్. అది
నేను పెడుతున్నా సార్, తొందరలో వీఆర్ కీపింగ్ ఎ మీటింగ్ సార్.
డోంట్ టేక్ కామెంట్స్ ఇంటూ కన్సిడరేషన్. అదంతా ఎప్పుడు మనిషి మన భారతదేశంలో ఒకటే ఉంటారు.
Waiting for that, sir, to meet personally.
Definitely. We will.
We will tell our gratitude to this sir.
Surely. Thank you very much. We'll definitely see, sir. Sir, question here starts from now.
Sir, namaste, sir.
Namaste.
Sir, నేను పర్సనల్ గా వచ్చి కలిశాను సార్ని. సార్ మీ క్లాస్ల వల్ల నేను 5 years నుంచి నేను నా సీనియర్ దగ్గర ఏదైతే నేర్చుకోలేదో లాస్ట్ 40 days నుంచి నేను రెగ్యులర్ గా ఫాలో అవుతున్నాను. సార్ ఎవరు నేర్పియారు సార్, అది ఎవరు చెప్పరు. ఇంకొకటి ఏంటంటే సార్
నార్మల్ సీనియర్ ఎందుకు చెప్పారంటే ఆయన కన్నా గొప్పోడు కాకూడదు, గొప్పోడు అయితే ఆయనకు ముప్పు రేపు.
సార్ ఇక్కడ ఎలా ఉందంటే అడ్వకేసీలో నేను అబ్జర్వేషన్ చేసింది లాస్ట్ ఓన్లీ కాల్ వర్క్ చేయండి, డేట్లు తీసుకోండి, అడ్వకేట్ చిన్న ఐఏఎస్ వేయండి, ఇంతే తప్ప క్లయింట్ ఉండదు, డిస్కషన్ ఉండదు. బట్ ఇక్కడ సబ్జెక్ట్ నేర్చుకోవడానికి క్లయింట్ తో ఇంటరాక్షన్ కి కూర్చున్నామన్నప్పుడు ఏదో ఒక పనితో పంపిస్తారు.
ఇప్పుడు కాన్ఫిడెన్షియల్ అంటారు, లేబర్ వర్క్ చేపిస్తారు తప్ప దానిలో ఉన్న లాజిక్స్ క్లయింట్ కౌన్సిలింగ్ లో చెప్పాలి.
ఇప్పుడు ఏదైతే నేర్చుకుంటున్నామో సార్, రియల్లీ సార్ నేను నిజంగా చెప్తున్నా సార్, మీకు పాదాభివందనాలు సార్. ఎందుకంటే ఇప్పుడు మీరు ఇంత వయసులో కూడా కూర్చొని మాలాంటి వాళ్ళకు ఒక దారి చూపించడానికి మీకున్న అనుభవాన్ని అంతా రంగరించి మాకు కూడా ఒక దారి చూపించడానికి ముందుకు మీరు ప్రతిరోజు మీ ఉన్న ఓపికతోని 1 గంట నుంచి 2 గంటలు కూర్చొని మా కోసం కష్టపడుతున్నారు సార్. తప్పకుండా మీ యొక్క కష్టానికి మేము మిమ్మల్ని మార్గదర్శిగా ఉంచుకొని మా ప్రయత్నం మీ పేరు పెట్టుకొని మేము చేస్తాం సార్. ఎవరేమన్నా కూడా పట్టించుకోకండి సార్. మీ విద్యార్థులం మేము, నిరంతరంగా విద్యార్థులమే. మీ ఆశీస్సులు మాకు కంపల్సరీ ఉండాలి సార్.
థ్యాంక్ యూ సార్.
The student negative on seniors, actually the student go negative on seniors, but any enthusiastic person can do, with their interest they can learn everything.
Exactly.
మా సార్ మాకు అన్ని అక్కడ మా సార్ కూర్చున్నాడు, ఆయన మాకు అన్ని దాన్ని అంటారు బాగా పోసాడు ఈయన.
సార్ లాలో ఎవరు చక్కగా ఎవరు నేర్చుకుంటారు చెప్పండి. కాలేజ్ ఇక్కడికి వచ్చినాక అట్లీస్ట్ బుక్స్ ఆర్ అవైలబుల్, బుక్స్ అన్నా చదవండి. And we should always think that we are a learner, we are not a perfectionist. Let's next slide.
Please go ahead with the question, sir.
చెప్పినప్పుడు
interactions
వాళ్ళు కూడా ఆథర్స్
Now interaction starts.
సార్ రామకృష్ణ గారు మిమ్మల్ని ఆపేస్తున్నట్టు 45 నిమిషాలు ఉంది. ఇంటరాక్షన్ ఏమైనా ఉంటే క్వశ్చన్స్ ఉంటే ప్లీజ్ గో హెడ్ సార్.
ఓకే సార్, థ్యాంక్ యూ.
చిన్న క్వశ్చన్ సార్.
చెప్పండి.
హైపోథికేషన్ అన్నప్పుడు ఓన్లీ ద మిషనరీ ప్లాంటెడ్ టు ది ఎర్త్ ఈస్ కాల్డ్ హైపోథికేషన్ కేస్ అన్నారు. బట్ ఈవెన్ వెహికల్స్ ఆర్ ఆల్సో డూయింగ్ హైపోథికేషన్.
హైపోథికేషన్ చేస్తారంటే దాంట్లో ఒకటి ఏమంటే హైపోథికేషన్ లా ది ఫస్ట్ చార్జ్ ఈస్ ఆఫ్ ది ఫైనాన్షియర్. The first charge, he has got a right of lien over it. Suppose you don't pay the higher charges or installments, the vehicle can be seized. But the consumer court and other courts have said, give a reasonable notice of 1 month before you seize a vehicle. You cannot just seize it just for the sake of doing it. But unfortunately, what is happening is the only one duplicate key is with the higher, the financier. One key is with you. At any time, your vehicle can be taken away by exercising the right of lien. And previously, mafia used to do it. But now that has been discouraged now because of the present government, sir. Credit should go to the present government.
You said that hypothecation press, example of a press, sir. As soon as it is the ground, it is a hypothecation.
Yes, sir.
But whereas vehicle is not fitted to the ground.
Sir, the vehicle is not fitted, but fitted with nuts and bolts, and the body is built, sir. While if you remove dismantle the body, it becomes a mobile property, part by part. But once it is fixed with nuts and bolts, it acquires the characteristics of an immobile property. That's why it's called hypothecation. Okay. That's why loosely it is called pledge of immobile property. Nowhere
Okay,
in your dictionary also you cannot find the meaning of hypothecation, sir.
Okay, sir, I got it, sir.
Yeah. Yes, next Uday.
Mr. Uday, you can go ahead with your question. Sachin Garu, please go ahead with your question, sir.
సార్ ఏం లేదు సార్ సూరజ్ లాంటి వర్కర్స్
Just a bit, be a bit loud, sir.
Sir, please. కొంచెం
సూరజ్ లాంటి
Yes, Suraj Lam's case.
సూరజ్ లాంటి వర్కర్స్
Delhi Development Authority.
స్టేట్ ఆఫ్ హర్యానా.
Sir, I stand corrected, sir. Thank you. Because I only remember Suraj Lam's case.
ఇంకోటి సార్ ఇప్పుడు ఎంఓయూ నాట్ బేసింగ్ ఆన్ ఎంఓయూ దే ఫైల్ సూట్ సార్.
Yes.
ఇప్పుడు దాన్ని మనం అప్లై చేయొచ్చు.
Sir, MOU is also compulsory registrable under 17(1)(b, sir.
నాట్ రిజిస్టర్డ్ బట్ బేస్డ్ ఆన్ దట్ దే ఫైల్ సూట్.
You can raise that issue as a preliminary issue and say, let the court decide whether it requires registration or not under section 17.
ఓకే ఓకే.
మనం కాపీ చేసేది కూడా సరిగ్గా కాపీ చేయం సార్. అమెరికా నుంచి కాపీ చేసాం, బట్ అవర్ ఇండియన్ లా చూడం. And unfortunately, the companies are manned by company secretaries who don't advise the company also properly. And 100 rupees stamp paper మీద లీజ్ డీడ్ రాసుకుంటారు. రేపు కోర్టుకు వచ్చారంటే 10 times the penalty పడుతుంది దానికి. ఆ registration also it should be done. Actually, the company secretary should advise.
Yes, correct.
Right.
Okay, sir. Okay, sir. Thank you, sir.
Right.
Any more questions?
Hello.
Any Mr. Samsung?
Sir.
Mr. or Miss?
Sir.
Mrs.
Yes, sir. This is Lakshmi here, sir.
I expected it. You don't want your name to be known to us. Okay.
No, sir. Suddenly I joined into this meeting, sir. Just I saw in a group and I suddenly joined.
Please go ahead,
meeting,
madam.
so
I'm obliged.
Please
go ahead, madam.
Sir, actually, somebody made a GPA, sir. That is also registered in the registration office.
Right.
But the person who made a GPA wanted to cancel the GPA deed.
Yeah.
But registrar office person is asking that the GPA holder and the GPA
Exactly.
person
I wanted to refer that. Yes, madam. Yes, I know. I wanted
is there any exemption for that, sir?
Previously, they used to unilaterally do it. But now, because of the circulars being issued by the registration department, both the parties have to be present at the time of cancellation. But in case it is not done, the only remedy is to go by 31 to 33 of the specific relief act and ask for cancellation of the GPA, madam. Only through the legal process, you can get it done in case the other person doesn't come.
Yeah, thank you, sir. Thanks a lot, sir.
Welcome.
Any more questions?
Mr. Sam.
Yes, sir. No questions, sir.
Thank you.
Thank you so much.
Any more questions, sir? Please go ahead. Or else we can conclude the class today. Sai Prasad Guru regarding GWOP. Please unmute and ask the question, sir, directly.
Chat box లో పెట్టాడు చూడండి.
Sir, we are not able to understand. Sai Prasad, please go ahead with the question.
Sir, good evening, sir.
GWOP, that sir you are asking.
Yeah, sir. About unsound mind person, sir. We have to appoint an adult guardian of it.
Sir, as far as unsound mind person is concerned, whether it's the lunatic asylum or is the custody of some other person, and that person is called the next friend. Normally, the superintendent of the mental hospital is the person who he can initiate action on behalf of the unsound mind person if he is in the mental hospital. If not, the next friend of that unsound mind person can initiate action, sir.
Sir, actually, regarding whatever family pension claims, we have to file a guardian OP.
Yes, GW.
Yes, sir.
Yes. You can file it in the two courts, either in the family court or you can file it in the Chief Judge's court, sir.
Okay, sir. Thank you. Sure.
Yes. Any more? Sir, all right. Can we conclude the class today? See you again tomorrow. Bye bye. Thank you.